So, welcome everybody to this debate match of the Inter-University Law Debate Tournament. We are all the teams now for this match present, plus the organizing team, my colleague, myself, and as well one of the judges present in order to have this match. So this match counts for the group phase, the day one of the group phase. For the group E of this competition, we have the University of Manchester on one side, who will compete for the first time in this competition, and as well the University of Porto, as well competing for the first time. So we start giving the floor, but first, my name is Aurélien Orange. My colleague, Miss Urbanova, as well, is here. We'll be hosting the match together. So I would like to give the floor to the participants of this match. First of all, Miss Andrea Diana Panait. Could you maybe introduce yourself?
Yes, hello. My name is Andrea Diana Panait. I am doing global politics, second year at the University of Manchester. As Professor Laurent has mentioned, this is my first time being part of this competition, and we are thrilled to join the tournament.
Thank you. Thank you very much. Welcome. So now on the side of the University of Porto, Mr. Guilherme Alexandre. Could you maybe introduce yourself?
Hello, good afternoon, everyone. My name is Guilherme Alexandre. I'm in the third year of law school in the University of Porto, and although I debate a lot in British parliamentary model, this is my first time in this model and in this competition. It's going to be a pleasure to debate with you.
Thank you very much. Welcome. So now on the side of Manchester, Mr. Beach, Adam Beach, could you introduce yourself?
Hello everyone, I am Adam Beach, representing the University of Manchester, and it's a pleasure and honor to be here today.
Welcome, thank you very much. We have as well Mr. Hugo Rafael Foya Sobral Brito de Almeida.
Hello, good afternoon. I'm, as my colleague Guilherme, I'm in the third year of the law, on the course of law in University of Porto, and it's an absolute pleasure to be here with you.
Thank you very much. So there are two members for this match from the University of Porto. The third member does not participate to this match. So we have as well the presence of one of the judges, so Professor Shah, who is in Vanuatu in the Pacific Ocean. Could you maybe introduce yourself?
Hello, my name is Sophia Shah. I'm a assistant lecturer at the University of the South Pacific here, and I'm based in Vanuatu, Port Vila, Vanuatu. So it's around 3 a.m. my time here.
Yes, so
I'm looking forward to listening to this match.
Many thanks for connecting at 3 a.m. in the morning, so middle of the night. So many thanks, and we hope you will enjoy this debate, of course. And yes, as well, we have Amal El Abida on the side of Manchester. Could you introduce yourself?
Hello, my name is Emel. I'm a second year law student at the University of Manchester, and it's also my first time partaking in this form of a competition, and I'm delighted to be part of it.
Thank you, welcome. So today we will remind, of course, the topics that you had to prepare. You received it 7 days ago, and today you will be debating on the topic of international organizations, regional or global, have the obligation to intervene when receiving information that a member state may compromise the quality of a common resource. So you will have to debate, obviously, but it's based on the position you will get in a few seconds, because I will share my screen and you will see the allocation of the positions live with the algorithm. Up. So normally you should see a wheel. Yes.
Currently preparing the drawing of the positions. Side organizers, just a quick reminder. When you will have 30 seconds left of your speaking time, you will see a yellow card notification. You can still continue. You have 30 seconds to go. And when your speaking time is up, you will see a red card, which means you can still continue with your sentence that you were saying, but it's recommended to stop afterwards. Don't worry, on the side, we recommend you keep the call in the gallery view, so you always see the notification for yourselves.
Thank you very much. So as you can see, you have two chances for each university. So in favor of University of Manchester, against University of Manchester, or University of Porto in favor, or University of Porto against. So you just click in the center and you will know which position you will have during the debate match. So this is University of Porto will be against the statement for this match. It means, as a consequence, the University of Manchester will defend the position in favor. So concretely, the University of Manchester will defend the position that international organizations, regional or global, have the obligation to intervene when receiving information that a member state may compromise the quality of a common resource, while the University of Porto will defend the position that international organizations do not have the obligation to intervene when receiving information that a member state may compromise the quality of a common resource. So now I will stop sharing. I will stop sharing my screen, and my colleague will give the countdown for 5 minutes. You can close your camera and audio if you want to review your notes, and in 5 minutes we start the match with the University of Manchester. We cannot hear you.
Thank you very much. I would just kindly ask those of you who are not speaking just to make sure that your mic is muted.
Is it mine?
I'm not sure. So, opening up with the opening statements in favor of the debate statement, University of Manchester, you now have 4 minutes.
May I begin?
Yes.
Global conflict calls for global governance. Ladies and gentlemen, good afternoon. My name is Emel, and I would like to welcome you on behalf of the University of Manchester on our side of today's debate, where we stand in favor of today's motion. International organizations do have the obligation to intervene when receiving information about a member state compromising the quality of common resources. Before I move on to outlining our case, I'd like to define the scope of today's motion on our behalf. We take international organizations to be organizations such as the United Nations Security Council that have enforcement mechanisms. The obligation to intervene is not restricted to military action, and common resources are global commons such as air, the high seas, outer space, and cyberspace. I'd now like to outline our case, in which we establish the legality of said intervention. In my substantive, I'll introduce you to our first point, which is that international organizations have legal personality and are therefore vested with international obligations and duties. Adam will then cover our second substantive point, which is that international organizations have an obligation of due diligence. In the context of common resources, due diligence is expressed via the precautionary principle. The manifestation of this obligation for international organizations is the obligation to intervene. Lastly, Diana will then introduce our third substantive point. A compromise to the quality of common resources is a threat to international peace and security, thereby warranting intervention and falling under the threshold of 2.7 of the UN Charter. I would now like to elaborate on my substantive point, establishing the legal personalities of international organizations. To find that international organizations have any obligation to intervene, a legal personality of said international organizations must be established. So it presents the question, are international organizations subjects of international law? We argue yes, for the following reason. International organizations are vested with powers which flow from the tasks that are conferred onto them by member states. International organizations execute the mandates articulated by their member states in constituent treaties. In exercising these powers, they become legal personalities. This was confirmed in 1996 in the Nuclear Weapons Advisory, which established a principle of speciality. It was held that the United Nations Security Council has powers which flowed implicitly from the tasks that are conferred upon them by the member states. In the ICJ also confirmed in the reparations case in 1980, and I quote, international organizations are subjects of international law and as such are bound by the general rules and obligations of international law. That concludes my first premise. My second premise of my argument is that a concern for common resources is an object of international law. The academic characterizations of the issue of common resources as a common concern of human mankind declares that today's motion should be an object of international law. Let me establish why. The Nagimaros case held that the concern for common resources and the environment is a jus cogens norm. As we know from the 2015 Chargos case, in international law, a jus cogens norm creates erga omnes obligations. In this regard, the protection of the quality of common resources is of erga omnes character and vests international organizations with an obligation to protect common resources. This notion was confirmed in the 1992 Climate Change Convention. On that account, international organizations have legal personality and are bound by the principles of international customary law. Within these international laws and principles is the erga omnes obligation to protect common resources. My teammates will further elaborate on the derivative obligations of erga omnes obligations to protect common resources. On that note, I ask you to propose.
Thank you very much for your submission. University of Porto, you now have 4 minutes for your opening statements.
Good afternoon, everyone. As representing the University of Porto, we will start our exposition as to why we oppose this motion mainly based on three substantive points as well. The first one being that under the principle of permanent sovereignty over natural resources established by the Resolution 626 of the United Nations Assembly General, but especially under Resolution 1803 of 1962, this principle characterizes sovereignty over national resources as a necessary guarantee to people's rights of self-determination, as well as the non-interference principle, both characterized in Article 1st of the UN Charter. The second point is one that differentiates the legal personality of international organizations and states. While both are subjects under international law, the fact is under the aforementioned speciality principle, international organizations have a more instrumental role. This is important because in comparison to the more general and universal ends that states have, the capabilities of international organizations are different. They, in fact, need to have not necessarily a subsidiary role to states, but of um, one that helps states reach their goals under international law, which we hereby recognize that environmental concerns are under international customary law and by all kinds of binding treaties, a common concern of all international subjects. The third point that we'll then develop is based on working models that already exist of multilateral approaches that do not represent a threat to countries' sovereignty that already exists in cases such as the North American Agreement on Environmental Cooperation under NAFTA, as well as the Asian paradigm as compared to the European Union paradigm. So the main substantive point we try to make is that while international organizations certainly do have competence, we believe that they are, because of their specific characteristics, better suited to have a role of monitoring compliance in member states, managing and advising elaborating reports and advising member states in the creation of legislation at the national level, and serving as a platform of interstate dialogue. We don't believe that implementation and enforcement of compliance should be a task of international organizations. That means an a posteriori intervention. Why do we think so? First, as I already explained, the principle of permanent sovereignty over natural resources, which is also represented in the Covenant of Economical, Social and Cultural Rights in the Article 1st, as well as the Article 25 of the Stockholm Convention, and has been invocated by Portugal in the famous International Court of Justice case of Australia versus Portugal.
Thank you very much for your submission. We are moving now to the part of the rebuttals. University of Manchester, you now have 2 minutes for your first rebuttal.
Hi, may I begin?
Yes, you may.
Good afternoon, everyone. My name is Adam, and I'm representing the University of Manchester in this debate, arguing in favour of the motion. Firstly, I would like to address our esteemed opponent's argument regarding sovereignty over natural resources and non-intervention. My counter-argument to this is that compromise of common resources causes transboundary harm, which is outside the scope of domestic jurisdiction and therefore does not violate state sovereignty or the principle of non-intervention. Next, I will move on to my substantive argument. International organizations have this obligation to intervene on the basis of due diligence. As we know from the Corfu Channel case, the principle of due diligence is every state's obligation not to knowingly allow its territory to be used contrary to the rights of other states. It is customary international law that international organizations have a due diligent obligation with regards to common resources and intervention. This is based on the precautionary principle highlighted in the 1996 case regarding the Nuclear Weapons Treaty, in which judges stated that because environmental harm, which is very often the consequence of compromise of common resources, is irreversible and irreparable, a duty to stop harm from happening by taking necessary precautions arises. The principle of due diligence has been established in regards to compromise of common resources and transboundary harm. For example, the Trail Smelter case, which created an obligation of a state to prevent damage to another state. A state is duty-bound to prevent, reduce, and control the risk of environmental harm to other states. Whilst duty to prevent and duty to intervene are different, the manifestation of duty to prevent is duty to intervene when discussing international organizations. This is because in Pulp Mills, the ICJ stated that due diligence requires parties to use all the means at its disposal in order to avoid activities that cause significant damage to the environment of another state. If the UN is under an obligation to use all means at their disposal, then they have the obligation to intervene, as one of the resources of the UNSC has at their disposal is the strong enforcement mechanisms to conduct intervention. Therefore, international organizations have an obligation to intervene when receiving information that a member state may compromise the quality of a common resource on the basis of due diligence.
Thank you for your submission. University of Porto, you now have 2 minutes for your first rebuttal.
Thank you very much. We would like to understand in this debate that we both agree that something must be done and that international organizations have a duty to act. We, however, in the opposition, disagree on what this action is. We don't agree that this has to be an intervention that seeks to create compliance, but we understand that it is a work that is previous, a work that tries to make that states that are its member states will work together to seek these solutions, but not in the way that will force them into these solutions. My colleague brought before you that we need to respect the principle of sovereignty over the natural resources. And we say that obviously all principles are relative to each other, especially in international law and in international relations where everything has to be negotiated politically. We agree that it is relative, but we need to understand when it is relative. We don't agree that international organizations are in the best position to create the change that we need here, that are in the best position to create the compliance that we need here. We say that the role of international organizations is to leverage expertise, is to create standards, is to serve as a platform for states to talk between each other and to try to help each other comply. We don't think the UN should, through, for example, the Security Council, force states to do something, because we don't think that will be successful, and we need to think on what is really the scope of this debate. We are both trying to achieve global environmental security. This means that we are trying that problems that are common regarding the environment will not result in conflict and will not result in worse relations and in worse protection of the environment. We say that doing this in a top-down manner will result in worse conditions and will make that states are less likely to comply in the future and are less likely to accept these solutions. Thank you very much.
Thank you very much for your submissions. University of Manchester, you now have 2 minutes for your second rebuttal.
Thank you. Hello, my name is Diana Panait, and I'm glad to be the third speaker of the University of Manchester in our debate today supporting the proposed motion. Now, first of all, I would like to take a step back and mention two of the arguments that the opposition team has now raised. First of all, they have mentioned the issue of the principle of sovereignty, which I will attack in my second point today, in my point. Then they have mentioned the need for soft solution, which wouldn't oblige any of the member states to actually take action in regards to what would be the compromise of common goods. Now, my main argument is regarding the applicability of acts and charters in the intervention over said domestic affairs. Now, I will divide my point into three sections. First of all, I will discuss about the compromising of the quality of common goods as being in fact a threat to international security, thus highlighting the urgency which wouldn't be viable in the case of soft solutions. Second of all, I will discuss what we understand by domestic affairs and why the compromising of common goods goes under some sort of general general jurisdiction. And thirdly, I will discuss about them potentially becoming a crime against humanity. Now, first of all, I want to discuss about point 2.7 of the UN Charter, which prohibits the UN intervention over domestic affairs. Now, the exception to this point is actually Chapter 7, which allows the intervention of the UN in the case of threats to international security and peace. Now, we have an effective mechanism in place, which actually allows the UN Security Council to take binding decisions and give out warrants to intervention. Now, we believe that this is an efficient mechanism which actually allows the UN to legally take action. Now, secondly, domestic affairs. We want to highlight the fact that because of the nature of these common resources, we have to understand that they are in themselves subject to some extent of international jurisdiction. Now, this again is highlighted in Article 1 of the Genocide Convention, which highlights the principle of sovereignty as a responsibility. Now, if the responsibilities of the states are not met, therefore, we take action.
Thank you very much. University of Porto, you now have 2 minutes for your second and last rebuttal.
Finally, we need to make clear that the framework under which most of international environmental law was built was a multilateral framework by binding treaties between states. While international organizations have been created by said treaties, the reaches and the competences of those international organizations under the speciality principle have always been quite limited, and states have always taken the central and primary initiative in the development of this harmonization in environmental legislation. There's a striking exception, which is under EU law, but we believe that there are also other very effective models. One key difference that Professor David Hell in his International Environmental Law Handbook devises is the differentiation between what's called a managerial approach to compliance and an enforcement approach to compliance. The position of the managerial says that non-compliance, that means infringement or lack of implementation of environmental norms by states, is often due to complex issues such as lack of capability or structural issues, which are not necessarily the fault of these governments. So the correct framework is to incentivize compliance. And a very good example of that was with Russia under the Montreal Convention of 1987. Russia wasn't complying with its CFC reducing objectives. So other parties, not the organization, but other member states, managed a phase-out plan so that Russia could close its factories. It managed to comply in 2002. Thank you very much.
Thank you for your submissions. We are now in the part of conclusions. University of Manchester, you have 2 minutes.
Thank you for the recognition. In our closing statement, we will now once again want to summarize our case and prove why we believe our proposition case is much stronger. And indeed, we have proven the obligation of international organizations to take action and intervene in the case of the compromising of common goods. Now, we have to highlight that urgent situations need urgent solutions. And this is why we believe that through our argumentation, because of due diligence, because we understand that this certain compromising of common goods represent a threat to international security, therefore allowing for Chapter 7 to take action. For these reasons, we believe that it is important and we have proven the obligation of international organizations to intervene. Now, the question of sovereignty, once again, we have highlighted and proven that because of the very nature that the environment, which is the main subject of these common resources, because of the nature of the environment and the irreversible harm that can happen to it, and the great scale of this situation can actually determine a threat to international security and even a crime against humanity. Now, as our first speaker has mentioned, in the Rome Statute, Article 7, 1d, crimes against humanity are indeed also about deportation and forcible transport of population. I'll only mention the example of Tuvalu. How can we understand that in a situation as urgent as the one in Tuvalu, in which the compromising of common goods, which is high seas, has been affected, and indeed high rising sea levels determine populations to flee their country and move to a new location, even become asylum seekers or environmental refugees? We believe that the obligation was proven and that interventions should be urgent, and we have the mechanisms in place to be able to enforce them. Thank you.
Thank you very much. University of Porto, you have 2 minutes for your conclusion.
Thank you. So in this debate, what we debated mostly is the difference and the clash between the principle of sovereignty over natural resources of a state and then the need to act on the potential harm to resources of other states. We said that it's more important to understand how we want to act than necessarily to act. We are going to act on both sides. This is something that has to be understood in this debate. In both sides, there's going to be action. In their side, in the proposition side, they are going to act in a top-down manner from an international structure, such as, for example, the United Nations. So they are going to pass a resolution that says this state will have to comply in this manner or else. And in our side, we are trying to use already existent multilateral cooperation structures that will show a state, here is the status quo, here is what you can do, and here is where you can go. Otherwise, we still have, if this doesn't work, understand, we still have the International Court of Justice to understand what damages are being done and what should be the sanction. But we understand that it's much better and it's much more likely to affect global security if you do it their way. If you do it the way that is more violent, the way that is more aggressive, states are less likely to comply. And in the other hand, in our side, my colleague has brought before you just now that Russia, for example, was made comply in a way that was much more, let's say, friendly, in a way that was much more pacific, because they were incentivized. There was a multilateral incentive-based approach that, with conversations and with many deals and negotiations, they were shown they can do better, and it will be better for them and for their neighbors in the region. So that's what we are defending here. We are defending the managerial approach instead of the enforcement system, because we believe it will pose less threats to the system and have better results. Thank you.
Thank you very much. Well done to both teams.
So yes, now it is time, because it's the end of the evaluation, so it means after that moment the judge will not be assessing you anymore. So now we'll simply ask your feedback, your impression about this match, because it's the first match you have in the competition, and of course, that will be afterwards the end of this session. So I would like to give the floor to Miss Panait, Andrea Diana Panait. What do you think about this match, the performance of your team, your own performance, the other team as well?
I definitely believe it was a good match. We definitely both had very substantive arguments and very broad arguments. Now, it was very interesting to delve into the format of this debate and kind of actually see and participate into, the one-on-one clash of arguments between the teams. So it was definitely a very productive experience.
Thank you very much. On the side of Porto, Mr. Guilherme Alexandre, what did you think about this match, your own performance of the other team?
So I will try not to comment on performances because I will be sad to talk about myself. But I want to say that my English actually did better than I was expecting. Not perfect, but better than I was expecting, and that's good. And that about the style of debate, it was pretty interesting to see. Like, we prepared for both sides, both teams prepared for both sides, and so we were listening to them and we're like, yeah, you're right, we studied that. And then I bet they felt the same too in some parts. So it was very interesting to have this debate.
Okay, very good. Mr. Beach, Adam Beach, what did you think about the match, your own performance, your team, the other team?
Yeah, I actually really enjoyed it. It was very fun. I've actually never debated before. This is my first time I've ever debated in any competition. So it was nice to get some experience. And as my colleague just said, it's really interesting hearing the other arguments because obviously we have prepared for both sides as well. So it's quite fun, you know, to have that line of thinking as well.
Okay, very good. Thank you very much. And then on the side again of the side of Porto, Mr. Hugo Rafael Foya Sobral Brito de Almeida. So what do you think?
I want to thank everyone because this was truly a very constructive and amazing opportunity for us to build rapport and to put our competence to test. It's like Mr. Adam. This is not really my first time in competitions, but I was only in a moot court, which of course is a very different style, mainly because of difference in time. I very much appreciated this rapid fire style of intervention, though I admit a bit of failing in my part in adapting to the low amount of time. Though, as I said, it was a fantastic experience, and I want to thank all of you for being excellent debaters.
Thank you very much. Miss Amal El Abida, tell me.
I think I agree with everybody that this has been a delightful experience, very enriching, in fact. I want to thank, on behalf of our team, thank the other side for all of the preparation that has probably gone into today's motion. And it's honestly great to see that we're all capable of bringing the complexity of a motion like the one of today into 2 minutes of a speech, which seemed like an impossible task before we did it. So yeah, thank you for everyone.
Thank you very much. So now we'll give the floor to one of the judges. So be aware that that will be the first impression by one of the three judges. Professor Shah, who is almost reaching 4 a.m. in the morning in Vanuatu. Can you tell us what you liked, which kind of advice as well you would like to give to the teams?
I thought it was a very interesting topic, and students had some time to prepare for it. I could see that both teams had done a lot of research for the topic. They had prepared well, they had research on the law, they had research on the cases, and they had very persuasive arguments on both sides. And as they were submitting their arguments and rebutting the opposing team's arguments, they were also enjoying themselves. And that is the main thing, that you need to enjoy these sort of competitions. And at the same time, it was not an easy topic. So to see the views coming in, and like you have already said, that you prepared for both sides. So when you hear the other side making an argument, which was already in your arguments, if you are arguing for that side, that adds to the excitement as well. And you know that you're all on the right track. And so it was a pleasure to see all the students perform in this debate today. And it reminds me of my debate days back in uni. And yeah, it was fun. It was fun judging, and I wish you all the very best.
Thank you.
For the competitions to come.
Thank you very much.
Thank you very much.
So now we are almost closing, so I will finish with one last tradition we have in the competition, is to ask the participants if they have been in the other country of the opposing team. So have you ever been to Portugal for the participants from UK? So the three of you, yes, no?
No, I don't think any of us have gone to Portugal.
Okay. And on the side of Porto, have you been in UK, Mr. Alexander or Mr. De Almeida?
I personally haven't been yet to the UK, though I plan in doing so very soon. It's definitely on my agenda. Wonderful country.
Okay. And Mr. Alexander, yeah?
I have not gone to either like England, Scotland, you know, like the Great Britain, but I've gone to Gibraltar, so that counts.
Yes, of course, yeah. It's a bit closer. Okay, so maybe it's a good occasion to invite each other, of course, if you think going to Portugal or to UK. So don't hesitate. So, of course, I will ask to both of you, have you been in Vanuatu?
Sorry?
I was about to ask the students if they have been in Vanuatu.
Okay.
No? You should be... Yes.
Well,
Yes.
unfortunately not, but I hear it's a tropical paradise, so I would be very interested in visiting.
Yeah, so...
It is.
And Professor Shah, have you been in Europe already?
No?
No, okay, so in Porto and in London, you have to in Manchester, sorry, you have to invite as well when Professor will come. So personally, I've been in Fiji, but not in Vanuatu. But yes, I hope next time, even if it's very, very, very far. So many thanks to everybody. So this is the end of this session. So it means in a few days, the teams will receive the results by email. So they will receive, for example, the two forms. One from actually, they will receive 3 forms, one from each judge, so one from Professor Shah, and yes, then you will know your score, and of course that will be counting for the group phase. So next match will be in 2 weeks. You will receive the topic in next week actually for your match, which is in 2 weeks against another team of this group. So many thanks, and of course we keep in touch. Thank you, bye bye.